In this chapter, we're going to be talking about the alternatives to adoption. So I feel like I cannot stress enough, especially on my social media, my TikTok specifically, there are alternatives to adoption. They are better than in the legal sense, but they also need reform. None of these, by the way, well, I shouldn't say none of them besides family preservation, negate the trauma that the child will experience. Now, of course, family preservation is not always viable. And it doesn't mean that there won't be other types of trauma, but there is a lot that we can do as a society to recognize that we have to do better overall and change legislation. So let's read the chapter. Okay. Alternatives to the current system of adoption would include support for families in danger of losing their children for economic reasons, individualized custody, not ownership, kinship fostering, temporary or permanent child guardianship, an open system under under uniform fair laws, guaranteeing uniform rights, true and uniform birth records, joint public-private partnerships for family preservation and program oversight, and removing financial incentives for separating children from their families. Kinship care and custody. 20 years ago, wow, I can't speak today. 20 years ago, joint lobby efforts by Association of University Women, Planned Parenthood, and AM4 resulted in California becoming one of the few states which enacted a priority in placement statute enabling biologically related family members, particularly the grandparents, to have priority in placing children whose parents cannot care for them. Today, under the California Family Law Act, grandparents have rights often referred to as grandparents' rights. If the grandparents have established a loving and bonding relationship between the grandparents and their grandchildren, in which case the courts may find it in the child's best interest to allow grandparents to be joined in contested family law and visitation cases, and allow the grandparents' custody or a visitation schedule. Yet baby brokers and courts in every state have more often opted to send a message that the child is somehow better off adopted by strangers. Okay, guardianship versus adoption. In Washington state, more than 80% of children interviewed in a guardianship survey indicated they were very happy with their guardianship arrangements. About 86% of Washington children remained with their guardian until age 18. And this is in volume 14, number 1, page 124. The term legal guardian means the caretaker in the relationship. Temporary and permanent legal guardianship of the elderly, the disabled, and of minor children actually predates adoption in American law. Temporary guardianships are for emergency situations. Permanent child guardianships can help lessen the separation trauma, sense of loss, and identity conflicts that develop when children are adopted, particularly if they are old enough to remember their parents or cherish their own heritage, because private guardianship allows for the continued involvement of the biological parents in the lives of the children, at the court's discretion. Guardians can be relatives, friends, or others who know the child. In California, grandparents may have the priority in determining placement for a child for permanent guardianship or adoption. When married, either one or both spouses may be named guardian. Major decisions regarding the school, medical treatment, and consent for other major life decisions are made by the guardian. Parents retain the rights such as choice of religion, visitation, consent to adoption when parental rights have not been terminated. On accountability. Gosh, there's so much here. Unlike adoption that requires no monitoring once the adoption is finalized, guardianship requires accountability. In some cases, not all. Ada County, Idaho, enhanced accountability by establishing guardianship monitoring program that utilizes community volunteers for oversight as eyes and ears of the court to improve accountability as they monitor the care received by the most vulnerable in the population, the elderly, disabled, and minor children. The volunteer court visitors receive extensive training that provides them the ability to audit accountings, research case files, visit guardians and their wards, and report back to the court. The volunteers are trained in areas such as communication skills, interviewing techniques, abuse identification, physical and mental health issues, and community resources. Since its existence, the program has made huge strides in determining the status of hundreds of people who need help of a guardian or conservator. Reports are more timely, action in problem cases is prompter, and people are better served thanks to the crucial service. The discovery that relatives will adopt if fully informed of their options came about as a result of efforts to create alternative permanency options that built upon the cultural traditions of informed kinship care and informal kinship adoption among African Americans. So the informal is usually done by African Americans. They'll take care of their own without going through the legal court system, which I think is really amazing in most cases because they are loving and cared for, and they will make sure that they know that their heritage and will reflect back in their looks, which is so incredible and so important for the child. Now, obviously, some people would be like, what about possibilities of abuse? Yeah, unfortunately, those things happen, and I don't think that's good. But the point is, majority of it is a good thing. And so, while these systems aren't perfect, they are a hell of a lot better than adoption. Okay. The Adoption and Safe Families Act, ASFA, then defined the term legal guardianship as meaning a judicially created relationship between child and caretaker, which is intended to be permanent and self-sustaining as evidenced by the transfer to the caretaker of the following parental rights with respect to the child: protection, education, care, and control of the person, custody of the person, and decision making. However, a 1994 Illinois study by the Delegated Relative Authority, DRA, found that willingness of kin to adopt fell off sharply for children over age 11. Although the preference for adopting younger children continues, significantly gains have been made in the number of older children achieving permanence through legal guardianship. When a child cannot return home at whatever age, guardianship provides more legal protections for the child not found in adoption, including mandatory reporting, and the child does not permanently lose their biological family connections. That is so true. Legal guardianship initiatives at the state level have been instrumental in helping thousands of children achieve permanence. Post-permanency services and supports are important to the long-term success of those placements. Despite that, AFCRS data indicated an increasing permanence for guardianship. In the year 2000, a 77% increase over the year 1998, guardianship lost popularity amid hype from the adoption industry, and may be due to the generous cash subsidies available to adopters, and the fact that guardianship is not as profitable as the adoption for public and private agencies and attorneys. So, yeah, when you're doing legal guardianship, while it does cost something, I believe what I heard was about $10,000, and that's mostly for the lawyers. The agencies get nothing, right? That's number one. And number two, that's a small amount in compared to the range of 35,000 to 80,000 per child. So of course they want the adoption. Now, the reason that a lot of people, and I mean hopeful parents, don't want the legal guardianship is because of that ownership aspect. They feel that because it's not permanent in the terms of there's temporary versus permanent. It depends on the state. The the first family can fight back. It gets expensive, but it's possible. But they would have to have good proof to get their child back. And in most cases, I think they should. It would, again, depend on the situation, but that is something that happens. Again, it does not negate the biological family. It also doesn't negate their heritage, and it doesn't close and change records, which is really important, whereas adoption does all of that. But as we know, hopeful adoptive parents, and adoptive parents mostly, want to basically own the child. That's why they are willing to buy the child, or they do foster to adopt with the hope that they're quote unquote saving the child. There's a lot of problem with all of this. And those adoptive parents don't get enough training, if any training at all. Now, the foster care, they do get some training, but it's not enough. It's very relaxed and comparative to the guardianship in this case. And again, guardianship is not perfect, but it is better. Okay. Guardianship costs and subsidies. Oh, so we're going to talk about that cost. Let's talk about it. Guardianship is less expensive than either foster care or adoption. Cost of casework services, public guardianship administration, foster care, foster home licensing, and judicial review are no longer incurred when the child welfare case is closed. Without an attorney, the costs to obtain guardian status are small. For instance, court filing fees are usually under $200, and an investigation fee is about $450, which is used to pay an investigator to determine whether the applicant is an appropriate guardian for the minor of the child. Now, this is according to Alameda County, California. The main problem with handling this process alone is the requirement that all the minor's relatives be properly notified by the hearing by service of process if the prospective guardian cannot discover the address of the minor's relatives. The form must indicate due diligence in attempting to locate them. Okay, so I guess over kinship, that's what would happen. And that can get expensive. There are circumstances which require an attorney to handle guardianship procedures. 1. If the child's parents or some other party is likely to contest the guardianship, which does happen. 2. If the minor has substantial assets, more than $5,000. 3. If the minor lives in one state but the prospective guardian resides in another. 4. If the minor is physically, mentally, or emotionally disabled. 5. If the minor is Native American. Or 6. If the guardian plans to move the minor out of state. Attorney fees may be charged either as an hourly fee, for example, $150 to $300 per hour, depending on the attorney's experience and skill, which may involve anywhere between 5 to 30 hours, or for a flat fee that might be as little as $1,000. Clients who cannot afford attorney fees can contact the local volunteer legal aid program. In any event, domestic and even international guardianship, where allowed, is less expensive than private or independent domestic adoption, which ranges, as I said, from $35,000 to $60,000 to $80,000. Whew, sorry. There are different kinds of financial help that a guardian can obtain to help care for the child. Welfare, foster care payments, which often pay more than welfare payments. Kinship gap, the kinship guardianship assistance payment, pays the same as foster care payments if you are related to the child in dependency case. SSI, so Social Security Income, or State Disability, SDI, payments are available if the child has a disability, and also Medicaid, known as Medi-Cal in California. In one version of subsidized guardianship, the court appoints co-guardians to act in behalf of the child when the parents cannot do so. Co-guardians may be family, friends, or relatives. The co-guardian is like a caseworker in a family preservation project, but with access to the family and that no outsider can hope to achieve within time limits imposed on those efforts. And that's according to the New York City Comptroller Office of Policy Management, quoted in A Model for Subsidized Guardianship by Matthew Grosset, Diane Pucel, and Regina Peretta in New York in May of 1990. Also as well, Merrill Schwartz, Reinventing Guardianship, Subsidized Guardianship, Co-Guardians, and Child Welfare, Institute of Justice, from June 1993. Okay. Now, coming back to this, there is a separate chapter for this, but this is a little subchapter. So the gay, lesbian, and transgender parenting. While President Trump announced his plan to faith-based adoption agencies to reject same-sex couples as prospective adopters, the courts have struggled with the realities of the child's situation versus the desires of the adults in cases of gay, lesbian, and transgender parenting. Presently, one of the gay, lesbian, or transgender partners adopts the child of their partner, the child being conceived by donor insemination in the case of lesbian co-parents, or by surrogate in the case of the gay co-parents. Again, it is the child who must adjust in this case, not only to the burden of their abnormal status of being legal fiction adopted with secret origin, but also to the co-parents' struggle for sexual identity and acceptance. In 2010, Kansas State University College of Human Ecology Family Studies professor Walter Schumann knew that publishing a study arguing that children of gay parents tend to be gay also is an unpopular thing to do, to say the least. In 2006, Paul Cameron, who admittedly believes gay parenting is injurious to society, published such a paper that was met with very virulent response from the academic and popular press. The Southern Poverty Law Center even called him a Nazi, but Schumann's study is a meta-analysis of existing work. First, he extrapolated data from 10 books on gay parenting, whereas Cameron had only browsed 2 of them and offered no statistical analysis. Schumann noted that he would come across passages on children of gay parents who said they were adamant about not declaring their sexual orientation at all, yet they were categorized as straight when the passages could easily imply gay. When Schumann's study restricted the results so that they included only children in their 20s, presumably after they'd been able to work out any adolescent confusion or experimentation, 58% of the children of lesbians called themselves gay. 33% of the children of gay men called themselves gay, whereas only 5 to 10% of the children of straight parents called themselves gay. Schumann says And this is according to this is according to Study Gay Parents More Likely to Have Gay Kids by Paul Sis in 2010. Why place the burden of adoption make-believe on a child? Why not raise the child honestly as their guardians, or a parent plus guardian, as the case may be, rather than the two mothers or two fathers, plus a surrogate biological mother, etc.? It is only the legal ties of adoption, anonymous donor assisted conception, and the surrogate process that must be addressed, but also the false sense of entitlement to a child as part of the American dream that bad law encourages. All right. And the last option that they have, or that Lori Carangelo talks about, is called Adopt a Family. As early as the 1950s, Jean Patton, adoptee and social worker, published adoptees' stories and issues in the log newsletter of Orphan Voyage, and her books, The Adopted Break Silence and Orphan Voyage, referring to adoption as colonialism. Patton suggested an alternative may be to adopt a family. Patton wrote, "Merge the two families for the good of the child. Let the child have contact with both families with responsibilities shared, instead of legal conflict, which makes very lucrative profits for lawyers. Let there be a core of people who know how to encourage reconciliation in these situations. Let the child know their name from the outset and that they are loved and cared for by everyone involved. For this to succeed, we must learn adoption all over again and give it a new name. It is ridiculous for a society to spend thousands of dollars over the custody of one child who needs less conflict rather than more. In the same way that we now advocate getting government off our backs, let us get the lawyers, facilitators, and lobbyists out of adoption. Instead, let us find wise reconciliators and put them to work. We must save money, save souls for children, and give peace to those who bring them into the world." Decades later, Women's Alternative Center's Adopt a Family program was hailed a success, and that was she also talks more about this model programs that worked in section in part 1.